welcome to the Chapter 10 video lecture. Chapter 10 is the remaining crimes against persons. So Chapter 9 was all about murder and manslaughter. This chapter covers rape, battery, assault, kidnapping, false imprisonment, stalking, domestic violence. And we have a lot to work through, so we'll just jump right in. The most serious offense in this chapter is rape. It is considered to be the second most serious crime after murder. It is deemed serious even if there's not a physical injury, and is just considered different from other felonies. The rape laws have evolved tremendously over time. Common law rape was intentional, forced, non-consensual vaginal penetration between a man and a woman, not his wife. At one point, you had to have witnesses to this to be able to successfully prove it. And then under common law, sodomy was also prosecuted, which was the intercourse between two males. So those were the common law sex offenses. They were extremely hard to prove and not used very often. Whereas now we have a very different definition of rape. And we actually have, so we have two types of rape. We have aggravated rape and unarmed acquaintance rape, or sometimes it's called second degree rape sometimes. Aggravated rape is a rape by a stranger or an individual with a weapon who physically injure the victim, where the other form of rape is non-consensual sex between individuals who are known to each other. Majority of rape victims are raped by persons that they know. So most rapes are this unarmed acquaintance rape. As far as the law, rape is still a challenging crime to prosecute. Oftentimes, it is difficult to prove the perpetrator guilty beyond a reasonable doubt when there's only the words of the victim and the perpetrator to establish it. So it is very challenging to prove it beyond a reasonable doubt in that situation. Secondly, we have to start every rape trial from the presumption that the victim is telling an untruth, that the victim is lying, because the defendant has a constitutional presumption of innocence. They are entitled to a presumption of innocence, and that hurts the victim. So that premise can be challenging to overcome, and it also results in victims feeling like the system is not on their side, and also results in victims feeling it's just a challenging situation to be in if you're a victim, particularly with the defendant having this presumption, the defendant not being required to testify. If 12 people or a judge don't find the victim's story to be believable, or they have questions, the threshold may not have been met, which makes this extremely difficult. Now, under this section of culture, what this is getting at is that most rapes are acquaintance rapes. These rapes are less likely to be people are less likely to go to the police, and juries and prosecutors are less likely to charge and convict of these cases. So that results in underreporting of these types of offenses. Now, the old approach to these rape statutes was that the victim assumed the risk. Throughout the 70s and the 80s, we have statutes drastically revised to replace rape with, instead of just being one sex offense, into multiple sex offenses that capture touching, different types of and levels of penetration, different types of harms and injuries to the victim. The requirement that the victim not consent, victims used to have to prove that they didn't consent and show that they physically resisted their attacker. That has been removed. The corroboration requirement has been removed. The victim's sexual history is restricted to only past sexual relationship between the perpetrator and the victim, only to show that the perpetrator may have misunderstood the level of consent that existed. And there, with a marital exception to rape has also been removed, so rape can occur within a marriage. This example kind of grades out sexual conduct. This is, first degree versus second degree is requires touching of personal parts. It defines intimate parts. Third degree is sexual penetration by force or coercion, whereas fourth degree is sexual contact by force or coercion. So we have this grading and what these things mean. This is a kind of a fairly traditional way that rape is evaluated. Under the actus reus, the actus reus is sexual penetration by force or threat of force, which raises the question of what does force mean. There are two different definitions for what force can mean. As well as until the 1950s, there was an utmost resistance standards. Rape victims had to use all their strengths to resist the attack. And that has been overturned, but there's still remnants of these things. And so we saw in the 50s a reasonable resistance rule, which said that you had to, the amount of force used to repel needed to be reasonable. Most new statutes do not have this in the formal law, but in the common law these things exist, and some judges still incorporate this idea into their rulings. Extrinsic force here means it requires some physical effort in addition to the amount of force needed to accomplish penetration, whereas intrinsic force requires only the amount of force needed to penetrate. So intrinsic force is a lower threshold. Just the sexual penetration is sufficient to meet the actus reus. Extrinsic force requires that plus something else. So your book has an example, Commonwealth versus Berkowitz, which is decided by the Supreme Court of Pennsylvania in 1994. And this was an application of an extrinsic force. The court found that the perpetrator did not use extrinsic force, only intrinsic force. Therefore, they did not convict the perpetrator of the sexual assault, despite the fact that the victim did resist somewhat and did not consent. Now, as far as the threat of force element, actual force may not be required. The threat of force it depends on the circumstances. Again, remember way back to the very beginning, case-by-case basis, particularly here. Threat of force can require the victim be subjectively afraid, that they experience subjective fear, or we could require objective fear, which is would a reasonable person in that situation have also been afraid. Your book kind of explains that some factors that courts use to determine whether or not fear is reasonable are ages, physical sizes, mental condition, the physical setting, whether the perpetrator held a position of authority. Those are the types of factors that can be used to evaluate fear. I'll also go ahead and note that your book has another example about this 4 standards on page 400 and state in the interest of SMI. This is a juvenile case, which is why initials are used, and it's not state for so-and-so. There they find they're relying more on an intrinsic force standard, and they do find that the victim did experience a rape, and they do convict the perpetrator. So your book has 2 different standards here and examples of each one. Now, for rape mens rea, rape is a general intent crime. So as long as you intend to forcibly penetrate, that satisfies the mens rea. You might have a circumstance element that does have a different level of mens rea. So that is something to be aware of. These statutes really should be read extremely closely. Some states have changed, and states are divided as to whether or not to have this as a general intent crime or have a requirement that it be knowingly or reckless or purposeful. For instance, one of those tiers, it kind of goes both ways. We don't want to convict people of a very serious offense without enough evidence and intent, but we also have to recognize the extreme amount of harm that a rape victim experiences. And so these things are things that society has to grapple with and balance out as this is navigated, and it's very difficult. This is a very difficult area of the law to work in and be a part of. Extremely important, but very challenging. That was a lot to cover. If you have any questions at all, please feel free to reach out with that. The next part of the book deals with statutory rape. This is to have sex with someone who's under the age of consent. The age of consent in most states is 16, or some states have graded tiers, so someone who's 16 can have consent to have sex with someone who's up to 18 or 19, but not older than that. So some states have a range, some states have just a set age. Regardless, though, minors cannot consent to have, under a certain age, cannot consent to have sex. They just cannot, and even if they were willing to come to court and say that they consented, they just are not mature enough to legally consent. The law does not permit it. This is a strict liability crime in almost every state, meaning the victim, the actus reus is the sex of the minor. We don't have a mens rea, and the circumstance is that the person is under the age of consent. So that's all that's required to establish this. Sometimes there are examples in the law that I'm aware of where prosecutors will charge with a statutory rape crime instead of a more forcible rape crime because it's easier to prove. They know that they can get the conviction at least this way at a minimum. Whereas if they go forward with a forcible rape case, they do run the risk of the person not being convicted. So that does exist because this is more clear cut. And if you're curious about that, I can point you to a case as an example where that is explicitly stated that the prosecutor did that. Again, not very common, and I don't think that's incredibly common, but it does happen. Now, in 2 states, Alaska and California, you can present a defense of reasonable mistake of age, meaning the perpetrator can say, I reasonably believe this person is old enough to consent, and provide evidence why. For instance, if you met the person in an 18 and up bar, and they used a fake ID to get in, this might be enough to prevent you from being convicted. Most 48 states, though, there is not strict liability. Our next offense is criminal sexual contact. This happens when somebody that you know, your boss, a classmate, someone in a date, somebody in your doctor's office, who hug, fondle, stroke, kiss, or otherwise touch you when you don't want them to. Your book has an example. The defendant was charged and convicted of criminal sexual conduct, and then the case was remanded back for more proceedings. So they needed to clarify something. That is State versus Tristman. All right, so now we're going to shift our focus a lot and talk about assault and battery. So under the common law, these are two separate crimes. Most states have consolidated this into one crime of assault. Battery is an unwanted and unjustified touching, and it requires that there be bodily contact. Meanwhile, an assault is an attempted or threatened battery, an intentional scaring, and the victim has to have some awareness of this. So there is a little bit of a difference between them. This is the battery is the actual contact. This is the threat or an attempted battery, but the victim does need to be, or creating intentional fear in somebody. The victim has to be aware of this conduct. These are, again, have been combined in most modern statutes to just be known as assault. In those statutes, the actus reus is an attempted assault or threatened battery with the intent to commit battery or the intent to frighten the victim. Your book does have a couple examples of statutes here. I think that this is one of the crimes that is fairly easy to read through on your own and understand what it means. The next part of the book does discuss domestic violence concerns. It provides an example of the Ohio domestic violence statute, which is a fairly common structure for these types of laws. And then it does have a case example. And then the next crime in the book is stalking. So stalking is a voluntary act including following, pursuing, spying, harassing, and or threatening. And that the acts had to occur more than once. You're going to some states have a circumstance that this can happen more than, some states require this happen over more than one day. Other states require just more of a continuous, like a continuous several hour contact will be sufficient to satisfy this. So it depends a little bit where you live for this. States also define the mens rea here pretty differently. It can be everything from purposeful to reckless or negligent. So the criminal harm here is that you place the victim in fear. So this, and stalking is a more recent crime. Now, personal restraint crimes are the crimes of kidnapping and false imprisonment. These are crimes because they restrict your ability to come and go as you please. Kidnapping is the seizing and carrying away of the victim. This is also called asportation. You have to intend to confine or significantly restrain or hold the victim in secret for it to be kidnapping. False imprisonment is a lesser included crime of kidnapping, and it requires that you deprive somebody of their personal liberty without the asportation requirement. So if you hold somebody in their own home, but because you didn't move them, that might be false imprisonment. Also, it's important to note here that kidnapping does have degrees as well. Aggravated, it's usually divided into simple and aggravated. Aggravated kidnapping will involve trying to obtain a ransom, holding somebody hostage, having sex with them while they have been kidnapped, robbing, blackmailing, and the most serious kidnapping offenses can result in like a life sentence if these are treated extremely seriously. Your book has an example, People v. Allen, about how far you had to move somebody to kidnap them. So a mom put her kid in the car, ran up to close her garage door, and somebody jumped in and drove the kid back down the driveway. The mom was able to like get in the car. The person got out and left, and the first issue is, did he move her far enough to kidnap? And the court did find yes. So just a few feet is sufficient to satisfy this asportation requirement. Here are the list of cases. So for this chapter, definitely understand kidnapping involves imprisonment, the elements of stalking, the difference between an assault and a battery under the common law. But the bulk of this chapter does focus on all these issues related to sexual contact and rape. I think it's important to understand a little bit about the changes, the things that used to be required and are now no longer, like having your testimony corroborated, the amount of force that your husband couldn't rape their wife. You also should understand the levels of fear and the types of force there. If you have any questions about any of the material, please feel free to reach out. I look forward to working with you, and I'll see you next week.